Okay, hello and very good evening, everyone. I hope that everyone are doing fine and still staying safe wherever you are now. And welcome to the third episode of the Strata Talk Show this beautiful Saturday. Okay, my name is Ami. I'm your host for today's Strata Talk Show. So this Strata Talk Show, as you know, that are brought to you by the Excel Academy of Real Estate. Okay, so on today's episode, we are going to talk about the handlings meetings during pandemics. And for your information, this topic is actually a continuation from our previous seminar, which is happened last Saturday with Mr. Patrick again. So guys, if you have any question to ask to Mr. Patrick, feel free to write your question on the Facebook comment below. Okay, and hopefully we will entertain your question throughout the session or at the end of our session later. So, Mr. Patrick, how are you today?
Okay, I'm good. I'm good.
Okay, guys. Again, I repeat, our topics today is about handling meeting during pandemics, but this is a special episode as we are going to answer all of your questions. It's a Q&A sessions. So feel free to write your question on the on the Facebook comment below. Okay, and hopefully we will entertain your question at the end of our session later. So I think without further ado, let us welcome Mr. Patrick to start with the sessions.
Okay, thank you, Jamir. Okay, once again, I would like to thank all those who attended the webinar last Saturday. It's good to see so many of you attending. It is also good to see the kind of questions that are being asked. Um, I know a lot of people are afraid of questions, but I'm very happy with questions. Um, in fact, my lecturer, I had a lecturer who used to do this. Whenever a student asks a question which he cannot answer, he will come out forthright and say, frankly speaking, I do not know the answer to the question. Then you're going to say, however, if you can be kind enough to me, I will find out the answer for you and get back to you on this next week. In the following week, that's the first thing you'll do. You'll say, to answer your question last week, this is the answer. So I'm very much taken up by the fact that we do not always have answers to all the questions. Having said that, this is not an escapism, this is just a reality. What I want to highlight about the meetings, putting aside pandemics, is that all meetings must comply with some basic requirements. There are some people who like to say they call it the three C's of a meeting. So I'm not too sure whether that's a correct way of saying it, but nevertheless, the first C is what we call convening a meeting. So we have the two key areas where meetings are being conducted, and that is at the JMB level and the MC level. We talk about a further breakdown, first AGM and subsequent AGMs and EGMs. So the first thing is about the convening of the meetings. And this convening of the meetings talks about notices, the number of days notice that is required to be sent out, the form and format of the notice. Most of the time you read that the notices have to be in writing. However, the rules do not state exactly how the notices are to be sent. By AR registered post, by email, or by putting it into the boxes. I remember one of the participants questioning me on this, whether it is all right to put it into boxes. What I've gone through after last Saturday's webinar is it just says that written notice has to be given. If your house rules or the bylaws, additional bylaws of your condo project or your strata project has any specific ways of dealing with that, then you will have to comply with that particular way of convening a meeting. Now, the next thing, of course, is the conduct of the meeting. It's one thing to call for meetings, to send notices. The next is how you conduct the meetings. Yet we have seen, according to the Act and the regulations, the things that are to be done. The first rule of any AGM or EGM is to elect a chairman. As I've said before, the chairman of the management committee is not the chairman of the meeting. The floor needs to elect a chairman who will take conduct of the meeting. There must be proper agendas, right? There must be proper agendas. Please be informed a meeting is a place to make a decision. A meeting is not a discussion forum. A meeting is a place to make decisions. That is why people have to be notified ahead of time what is the agenda, what is going to be discussed, what kind of decisions that are going to be taken or that need to be taken at the end of the day. Please be informed that in a strata project, you do not call for meetings to discuss matters. That is done at the committee levels, not at AGMs, and certainly not at EGMs. So that is a very important thing to keep in mind. So how you conduct the meeting. And the third part of it, of course, is the various decisions that are taken. And this is where issues like voting comes into the picture. So you have the convening of meetings, you have the conduct of meetings, you have all the various resolutions that need to be passed. This determines the whole aspect or the scenario, the panorama of any particular meeting. So, in the process of um, the third C, some people ask, what is the third C? The third C is actually the constitution of a meeting. Who is entitled to attend and who is entitled to vote? That is the constitution of a meeting. Now, having said that, so three C's, please take note. Number one is the convening of meetings. Number two is the conduct of the meetings. Number three is the constitution of the meetings. Two or three, you can put it either way. You can put it as convening will always come first. You have to send out notices. Then you can talk about constitution and you can talk about the conduct of the meetings. These are the three C's of a meeting. Now, going one step further, there are general rules about meetings. Many years ago, when I was teaching for company secretaries, the ICSA program, the traditional ICSA program had 17 papers. One of the papers was company meetings. So they talk about the various kinds of meetings and the various rules regarding meetings. So there are many, you can say there are many uh, general rules or common law rules about meetings. And so our Strata Management Act does not touch on all of these rules. So where the Strata Management Act or the schedules are silent, you need to look at your own bylaws and see whether your bylaws, you have anything additional over and above that of the regulations. Because the Act provides that any stratified development can pass bylaws in addition to the regulations, provided they are not inconsistent with the regulations. So you may have additional rules. For example, there could be additional rules on pets, on securities, on the usage or restriction of usage of common facilities. So you can have additional rules. So you can look at these additional rules and see if there are anything pertaining to meetings. And if there are, follow them. If after looking at the Strata Management Act and the regulations and any additional bylaws, you cannot find an answer to a specific problem that arises in your property area, then you will need to look at the common law. What would the common law say? Let me give you one example. I had a Zoom meeting with my clients from Ipoh just now, just before this session. And while we were discussing some issues, they raised this question. The proxies nominated the committee members. So question was asked, can the proxy nominate a committee member at the AGM? Now, we know the rule is very clear. A proxy cannot be nominated as a committee member unless the proxy himself is a owner of some other property. Otherwise, he cannot be nominated. But can he nominate someone? If you look at the regulations are silent. It doesn't say so. But it also provides the proxy has all the rights of a parcel owner, except that he cannot be nominated. He can vote on a show of hands, he can vote on a poll, he can join the others in voting on a poll, and certainly he should be able to nominate a committee member. However, if the proxy is there and the owner suddenly turns up, the owner who appointed him as a proxy turns up at the meeting and the owner decides to vote or nominate someone, then obviously the proxy cannot act because that will amount to a double voting. So, likewise, there may be many rules, for example, regarding when the quorum must be there. One of the oldest problems in meetings is, must the quorum be present only at the beginning of the meeting or must the quorum be there throughout the meeting? This is also something which the common law gives an answer to. So if the regulations are silent and if your bylaws are silent, you may need to go back to your common law rules to seek the answer from there. Then there may be very, very novel situations, things which may have never happened before. There's always a possibility of things happening. The law is always catching up with society. That is why the law cannot always provide you with the answer. If there is a novel situation, then all we can say is let us wait and see how the court is going to decide. Last Saturday, I raised the question whether virtual meetings are valid in Malaysia. This is because although the Kementerian Keselamatan has come out with their SOPs, right? So the not Kementerian Majlis Keselamatan Negara, MKN, has come out with SOPs for phase 1, phase 2, phase 3, and phase 4. Nevertheless, the act is very clear that it is the minister who must come out with the rules. And we have also seen that the COVID-19 Act states any minister in charge of any area of the law may come out with certain rules. And we have noticed that maybe the minister in charge of stratified development, Kementerian Perumahan, has not specifically come out with rules but has asked the MKN to do so. One of the participants did put up in the chat box and say that he disagrees with me. With all due respect, he said he disagrees with me. He believes that the SOPs and the virtual meetings for stratified properties are valid. Now, I am not going to debate with him. I'm not going to disagree with him. I just beg to differ. However, I respect his views and I respect the fact that we are in a novel situation. We do not know how the court will decide this in the event the matter is taken up to court and the court has to come out with a ruling on it. As an illustration, for many years the JMB in a mixed development has been charging different rates, maintenance charges, especially where you have malls and shopping lots and then you have service apartments. However, this was challenged by a residential owner in the Rajawali case. We are all familiar with the Rajawali case, and nobody expected that the High Court, the Court of Appeal, will rule that the JMB has no power to impose varying rates. Only the MC can impose varying rates. How did the Court of Appeal come to this conclusion? Vernon Ong, the lead judge in this case, said when you look at the provisions, the powers of the JMB and the powers of the MC, it very clearly says the JMB is to determine the maintenance charges, but the MC can maintain and can vary. The fact that variation is specifically provided under the powers of the MC means the MC can do it, the JMB cannot. This was shocking to the JMB. Almost all JMBs in mixed developments have always charged lower maintenance rates for shop lots to encourage them, and the application to appeal to the federal court in the Rajawali case was rejected by the federal court. So the federal court did not allow the appeal, and because they did not allow the appeal, the Court of Appeal decision stands. Who would have ever thought that the Court of Appeal would come to this kind of decision, that the JMB cannot impose varying rates? How does this affect all the previous areas where the JMB has imposed varying rates? Can you now take this back and tell them, refund us back? We want a refund of our monies. It's a very interesting question. So these are situations which are novel, where the court makes a ruling and a lot of people are caught off guard. So we can't say anything because the court always does a catching up. Unless somebody brings an issue to court, the matter will just lie like that. If nobody comes to court and challenges virtual meetings, it's going to lie like that. But if they challenge it in court, I may be proven wrong. The court might say, let's be practical. During the MCO, during this COVID-19, you do not expect people to meet in physically. This goes against the entire purpose of the COVID-19 Act. They may say like that. Or they may say, show us where it provides for virtual meetings. So I could be wrong. And if the court makes a decision which is against my opinion, then I will stand corrected. Simple as that. We all need to stand corrected from time to time. We learn from that. So I encourage you, please bring your difficult and challenging questions. Even though I cannot get an answer or I might not be able to give you a definitive answer, I will most certainly try and I'll most certainly do my research and if necessary investigations to try and get an answer. And both parties will have a win-win situation. We will learn from here. So thank you very much for your patience. And I thank you all for listening and coming and attending the seminar, the webinar on Saturday. So where I could not answer your questions last Saturday, I will see if I can attempt them and at least try to see which part of the act may assist us in getting an answer to the various queries that we may have today. Thank you very much. Back to you, Mr. Encik Amir.
Okay, great. Thank you so much, Mr. Patrick, for the introductions and you do some recap on what we have discussed on last Saturday webinar. So now, guys, we are coming into the Q&A segment. So if you have any question about the topic that we are discussing today, which is handling meeting during pandemics, so you can write your questions on the Facebook comment below. Okay, Mr. Patrick, we have some question coming from our participant last week. Okay, and the first question is actually about the online meetings. Okay, thank you, Mr. Mr. Hasri Husairi. The question is, after 31st December 2021, are online meeting still allowed?
Yeah, that's a very interesting question, and I think I'm not sure because I used to read Sherlock Holmes. Sherlock Holmes is a very interesting character to read, and in one of the books, one of the stories that was written, a question was asked by Dr. Watson to Sherlock Holmes: "What do you think the criminal would have done later?" And Sherlock Holmes said, "Well, I can tell you the past, but I cannot tell you the future. We do not know what will happen. Number one, because I want to take the act itself, the COVID 19 Act. The COVID 19 Act allows the ministers to provide for alternative forms of meetings, which will be the online meetings. However, the Act itself has been enacted only for 2 years, and the power has been given to the Prime Minister to extend the Act. Now, when the minister extends the Act, this must be followed up by the Minister for Perumahan to extend any exemptions that are given, because we must understand there are two acts now coming into the picture. The first act is a Strata Management Act. The Strata Management Act empowers the minister to come out with various regulations. Number one, this is positive. That means the minister comes out with all the regulations. This may include allowing virtual meetings in the future. I would have thought the best thing the minister could have done is to make an amendment to the second schedule to allow for virtual meetings, because a power has been given to the minister. This is the positive part. The negative part of it is the minister may give exemptions. Those exemptions relate to no need to hold your AGM within the 15 months, within the 12 months, no need to present your accounts, those kind of things. Those are negative. Those have nothing to do with online meetings. Online meetings, I think the minister should actually amend the regulations, allow it, because he or she is empowered under the SMA. The second one is a COVID 19 Act, which allows any minister in charge of any department to provide for variations. Then he can provide, but that will be temporary. SMA will be permanent, COVID 19 Act will be temporary. So now itself, we are already in phase 4 in Kuala Lumpur. So maybe after, and they've, according to phase 4, as we saw the SOPs, not only to strata meeting, we look generally, kenduri-kenduri semua dibenarkan, they put there. Perkawinan dibenarkan. 100% attendance at work dibenarkan. So they may say, well, you can have your physical meetings. We don't need online meetings anymore. So we need to see how the COVID situation progresses. If the numbers really drop low, we reach stage 5. Phase 5 means everything is open fully. That may happen, then they may do away. I remember last year, I stand corrected, but maybe Encik Amir can correct me. Last year, when we went through the recovery period, actually the Human Resource Ministry started saying they don't want webinars or online meetings. They were encouraging physical meetings again for a short while. Then when the numbers spiked up again, they went back and said back to webinars. You see? So who is to say what is going to happen after 31st? I really do not know. Anything can happen between now and then. Thank you, Jihazri.
Understand. Thank you, Encik Hasri, and thank you, Mr. Patrick. And the next question, I believe, is about the voting, Mr. Patrick. Okay, and the question is coming from Miss Azwaliana Muhammad. Okay, the question is as we have voting answer, for example, yes, no, abstains, do we still need to have the proposer and seconder now names to be recorded for each agenda?
Yes, I think we should have uh, that, because the AGM actually is a fixed agenda, right? There is a minimum requirement for AGMs every year, whether it's a JMB or MC, what needs to be done at each AGM. And they always say you elect a chairman, number one, number two, the chairman then proceeds with the meeting. They may go, the first thing is to go through the minutes of the previous year's meeting, and then they go through the accounts, and then whatever other resolutions need to be passed. You will see on record who proposes it, who seconds it, and then the voting takes place. So it is good recording, because I think that is very important. Uh, like, I remember reading one of the minutes of a meeting in which the person actually said the minutes of the previous AGM was incorrect, because the person said, I was not there at the meeting. So sometimes a person could have attended a meeting and left halfway, but in the mind of people, that person was there. And then maybe the person secretary taking down the minutes may have missed out certain things. Can you imagine if you have a meeting where a few hundred people are there and everybody's talking and making noise, you're bound to miss out something along the line. So it is always good to have the proposer and the seconder names to be recorded for each agenda in case of a challenge coming up later. The courts, always remember, the courts don't know what happened. The courts or even the tribunal can only look at things from the minutes, and they will need to know. Yes. Okay.
Okay, thank you so much, Mr. Patrick. I hope Mr. Patrick answers your question, Ms. Azwalina. And the next question is about JMC meetings minutes, Mr. Patrick. And the question is coming from Miza. Is there any requirement in SMA to publish the JMC meetings minutes so that the owners can read and understand the plans for the development?
No, JMC meetings, now it is like this. The JMC meetings, the notice of the meetings must be put up in the notice board, so that anybody, any parcel owner, can inform the committee that he or she intends to attend the meeting. So any parcel owner can attend a JMC meeting. However, only the committee members can vote. The non committee members are just observers. They just have to listen. They just can want to see what is going on. As such, they are not entitled to the minutes. They are not entitled to the minutes. So you can't ask the JMC to publish this. It will also, or it may also cause embarrassment, because the JMC will be talking about things like what kind of action to take against defaulters. People could have complained about issues like nuisance, neighbors being, a nuisance. If your neighbor happens to feel that he can practice a drum only at 3 a.m., then that is going to be a nuisance. You are definitely going to complain about it. So there could be a lot of sensitive issues that come out during JMC meetings, and these are not to be made available to the members. So they won't do it.
Okay, great. Thank you so much. And Mr. Patrick, the next question is about kelayakan pembeli sub-sales untuk menyertai AGMs. Okay, and this question is in Bahasa. Okay, and the question is coming from Encik Jamaluddin bin Harun. The question is, bagaimana kelayakan pembeli sub-sale untuk menyertai AGM sebagai pemilik petak ditentukan? Memadaikah sekadar perjanjian jual beli?
Okay, let me answer it in Bahasa. I think I can answer it in Bahasa. Right? Okay, Cik Jamaluddin. Sebenarnya dalam persoalan ini, ia bergantung kepada sama ada Ianya adalah JMB ataupun ia adalah MC. Sebab kalau dilihat kepada Akta Pengurusan Strata mengenai JMB, JMB menggunakan perkataan atau frasa pembeli. Sebab pada tahap JMB sebelum pemerolehan strata, hak milik strata, ianya hanyalah pembeli sahaja. Tetapi untuk MC, ia menggunakan perkataan proprietor atau pemilik. Sebab MC itu sebenarnya adalah pemilik yang berdaftar. Terdapat satu perbezaan. Jika seseorang hendak hanya membeli dan memasuki perjanjian jual beli saja dengan tanpa memiliki hak milik strata, pada tahap MC, beliau bukanlah seorang pemilik berdaftar lagi. Jadi, ini akan membawa kesusahan. Tetapi kalau JMB saja, JMB adalah terdiri daripada pembeli-pembeli. Jadi, kita boleh menggunakan perjanjian jual beli sebagai bukti bahawa kita adalah pemilik. Walau bagaimanapun, pada masa yang sama, JMB itu mesti, perjanjian jual beli itu mestilah diselesaikan. Misalnya, bila kita memasuki perjanjian jual beli, kita hanya membayar 10% sahaja. Ini tidak boleh memberikan kita sebarang hak sebagai pemilik beneficial, pembeli beneficial. Kita harus membayar keseluruhan harga jualan. Dan kalau kita dan juga memasuki apa-apa deed of assignment dan sebagainya, barulah kita dijadikan seorang pemilik beneficial. Dalam satu kes, Mahkamah Persekutuan, masa itu Mahkamah Agung, ya, Supreme Court berkata seorang boleh dianggap, seorang pembeli dianggap sebagai pemilik beneficial hanya sekiranya dia telah melakukan segala apa yang diperlukan untuk dilakukannya di bawah perjanjian jual beli tersebut. So, terdapat perbezaan di antara JMB dengan MC. Alright.
Okay, great. Okay, Mr. Patrick, there is another question about voting again, voting by poll. And the question is coming from our participant, last Saturday participant, which is Mr. Alfred. Okay, the question is, voting by poll will be based on the basis of share units allocated for each parcel. However, in many mixed developments, different rates have been practiced in the market during the JMB period. Will this vote still be valid? And will there be a retrospective effects towards the decision made in the earlier AGM?
Okay, we must be clear about two things. One is the rates that are fixed for the purpose of maintenance charges. Now, these rates actually do not have any bearing on your share units. So, for example, in a mixed development, they may say the rate is 1 for residential, 0.85 for, let's say, commercial, or 1.5 for commercial. Those are rates. However, the main thing is your share units. How many share units has been allocated to you? Then you vote according to the share units. 1 unit, 1 vote. So 1 unit is 1 vote. So obviously, if your area is larger and you have more accessory parcels, you'll be paying a greater maintenance fee and you will have greater share units. So your voting will go higher. It's your share units. That is the key. It is not about the ratio. What happened in the case of Rajawali is the imposition of different rates for whether yours is commercial lots or residential lots. But for voting, it's not the rates that count, it is the number of share units you have. One unit, one vote. So it goes on that kind of basis, right? Now, further, uh, challenging any previous decisions will depend on what the decisions were all about. What were the decisions all about? Now, for example, uh, if it was like a Rajawali case where different rates have been charged, maybe the law will require, if you go to court, you look at what are the consequential orders of the court. The court may order that you go backward retrospectively and start calculating everything all over again. However, we must note everything will start only from 2015 because that's when the Strata Management Act came into effect. Nothing can go beyond that. You see? So none of the acts have retrospective effect. Just that from 2015 onwards, the Strata Management Act starts. Anything is done according to the act from that day onwards. Right? So that's how it works. So you go according to your share units, not according to the rates. Thank you.
Okay, great. Okay, the next questions is about the submission of resolutions. The question is coming from Encik Akram Muhammad. Okay, the question is resolutions submitted from proprietors for upcoming AGM or next AGM. If defaulters submit the resolution or motion, should be forwarded to AGM or considered invalid.
Okay, defaulters are not allowed to vote. They are allowed to attend the meetings, but they are not allowed to vote. If you are not allowed to vote, you cannot submit any resolution, any motion to be discussed or to be debated. It is as simple as that. So they are not allowed to come in. So any resolution is coming, the law requires that if you want a motion to be discussed, of course, generally the JMB or the JMC or the MC, the committee, will determine what are the items for the AGM, the agenda for the AGM. The statute already decides some of it, but the statute also says any motion which has been received not less than 7 days before that AGM can be or should be discussed. It must, of course, any motion must come from a qualified person, meaning you must be a parcel owner, number one, or a purchaser. Number two, you must not be in default. That is why they said 7 days before you must put up the list of defaulters so that you will know who can and cannot vote. All right.
Okay, Mr. Petri, I think this next question is related to this question, which is an resolution or motion submitted against the Strata Title Act should be discussed in AGM.
Um, you're talking about against the act. I'm not too clear about what you mean by against the act. Are you suggesting that the motion that is proposed to be tabled at the general meeting is something which goes against the act or any provision of the act? Now, such motions should never be discussed. It should never be discussed. Simple as that. Because the Strata Management Act clearly provides that you cannot contract out of the act. The act is supreme. You cannot say, okay, forget about the act, what the act says, we will do this. No, you cannot do that. You see? Let me give you an example which I've given quite a number of times before. In the case of PJ Center Stage, for example, in PJ Center Stage is a pre 2013 project, is a pre 2007 project, in fact. So everything was done on square feet basis. The maintenance charges was square feet basis. It was not done on the this thing. And since the act has come into place, they have applied to convert it into share units. but in the process of conversion, there were some errors. It appeared that larger units had less share units, smaller units had more share units. So obviously there was an error, and the whole thing was sent back to the Pejabat Tanah and Galian for recalculation. So during this time, there was an AGM being held, and one of the shop owners actually uh, wanted a vote by poll. And the chairman said, if you want to vote by poll, the Act provides that we have to do it by way of share units. However, our share units register is incorrect. There are errors. We have sent it back for rectification, so we cannot rely on it. Should we proceed with it, the problem we'll face is somebody is going to come and challenge it later. The PJ, Commissioner of Buildings, representative was there. Three of them were there. In fact, the PJ Commissioner of Buildings herself, the former commissioner, she was there personally at the meeting. And she said, by right, we should vote on a poll. If somebody asks for a poll, we should vote on a poll. However, since the book is not ready, we have to vote on a poll or a show of hands. What happened next? That person insisted that they vote by poll, and that if the error is appearing there, the AGM should be postponed or the item should not be voted upon. The chairman said, I'll open it to the floor. They took a vote, and the majority said, let's proceed with the meeting by a show of hands. Approximately 100 over parcel owners said, no, we want a poll. We are not in favor of show by hands. So the chairman said, I've discussed with the COB. The COB has given an opinion. I've asked the floor whether we should adjourn the meeting or not. Floor says proceed with the meeting. I asked further the meeting whether we can vote on a show of hands. They all say can vote on a show of hands. And so we decided to proceed. In the tribunal, Strata Management Tribunal, the decision went in favor of the JMB. But on judicial review in the High Court in Kuala Lumpur, the decision was reversed. The court said, can you tell me where in the Act or in any of the regulations it provides that the chairman can overrule any parcel owner who asks for poll? The answer was, cannot. There's no such provision. So it's very simple. The court is going to ask the question, show me where it provides. This morning I had a Zoom hearing from Ipoh High Court, also on strata properties, and the court asked the proposed interveners who wanted to intervene in the suit, can you show me authorities, cases, sections which provide for what you're asking? Because the law is very clear. You cannot contract out of the Act. Even if you have a unanimous decision, the chairman of the meeting should actually inform that nothing should be done against the Act. Nothing should be done against the law. What is the use of discussing something if you are not going to vote? Let me tell you, AGM is not a place for discussion. AGM is a place for decision. That's resolutions. You discuss for the purpose of getting different opinions and then voting on it. Can you vote on something which goes against the Act? The answer is no. If you look at the powers of the Strata Management Tribunal, they can nullify any resolution. So if your resolution goes against the statute, any statute, why discuss it? The chairman should be astute enough to tell. Don't waste time discussing something you cannot vote upon. And not only that, you get somebody who will appeal against it and get it nullified subsequently. No, better not. Thank you.
Okay, thank you. I hope Mr. Patrick has answered your question, Mr. Akram. So the next question is coming from Ku Chun Hao. And the question is, how if the GMC or MC Council's members draw a fixed monthly allowance without obtaining written approval from COB?
All right. Now, the answer to this is, first of all, uh, being a member of a committee, whether it's a JMC or MC, is not a paid job. Number one, it is not a paid job. The minutes of meetings are sent to the COB. Anyone can raise complaints to the COB if allowances are being paid. There's no such thing as a fixed allowance. You may get some allowance for traveling expenses. Obviously, if you're staying there, you're not going to get any traveling allowance. What other allowances are you going to be entitled to? In the past, prior to the 2013 Act, committee meetings used to be held with a big fiesta. JMC, MC committee members all meet in hotels, right? Then they sit down there and have their whiskey and brandies and all kinds of food, and charge it onto the maintenance account and saying this is an expense. It is not an expense, it is a luxury, and that should not be allowed. It is as simple as that. Allowances are only paid. Allowance, the word allowance means it is an out of pocket expense. So, traveling, yes, it's an out of pocket expense. If you need to travel, then you get it. You see, the chairman of the JMB in Ipoh, although he has bought a unit there, he owns maybe one or more units. He's a chairman of the JMC there. He lives in PJ. So every time a JMC meeting is going to be held there, he obviously has to travel back to Ipoh all the way. And he will claim for his traveling expenses. So that is fair enough. But what other allowances are going to give? How can you give a fixed allowance if the JMC member does not attend meetings? Then what is the allowance for? No, that is not right. They cannot get a fixed allowance. Right? This will be serious breach of duty. And I would think the COB cannot approve because the COB does not have the power. You must look at what the powers of the COB. The COB does not have the power. The COB has the power to appoint an auditor to audit the accounts if people complain about misuse and abuse of funds. There was one case where the COB actually negotiated a settlement because common property was being rented out to people, and then at a very low rent or even free of charge, if I'm not mistaken. And some owners complained, and the COB negotiated a settlement, mediated a settlement, and decided what was a reasonable rent. Now, the tribunal decided the COB has no power to fix rentals for parties. That is totally outside his powers. So, no fixed monthly allowance is allowed, only out of pocket expenses allowed. Thank you.
Okay, great. Thank you so much. And the next question is coming from Mr. Sean Lee. And the question is about the eligible to attend meetings. Okay, hi there. I would like to ask first AGM to forms MC, honor which haven't claimed the title. Are they eligible to attend meetings and vote? Thank you.
Okay, this is a very interesting question because when you look at the Strata Management Act, who is an owner for the purpose of this act? Right? Who is considered to be an owner or a proprietor of the act? So you need to look at that. And once you look at that, you will get the thing here. Now, it says here in your Strata Management Act, the Strata Management Act in Section 2 on interpretation says proprietor as the meaning assigned to it in Section 4 of the Strata Titles Act. So it goes to the Strata Titles Act here, right? So proprietor means, now once you touch the Strata Title Act, let me tell you, you're already looking at parcel owners. Okay. Then you look at section 30 and 31, it talks about the register of parcel owners. Okay. the register of parcel owners. Now, once you've taken that, right, next you have to look at what Section 46 tells you from 46 onwards. The first AGM of the management corporation. Okay, now just give me a minute. It says here in section 57, the developer shall give written notice of the first AGM of the management corporation to all proprietors. To all proprietors. It doesn't say purchasers. It says notice is to be given to all proprietors. Okay? So we have to look at that provision. Then you go back to your Strata Titles Act. In the Strata Titles Act, does mention that a purchaser is to be regarded as a proprietor. So if a purchaser is regarded as a proprietor, then that resolves the question that you have asked. Now, just give me a minute. I will get for you the act and then I'll tell you what it states specifically. 1 minute.
Yeah, sure. While waiting for Mr. Patrick, so if you have any other questions, we have another 10 minutes before our session ends. Okay, write down your questions or anything that you want to ask to Mr. Patrick on the Facebook comment below, and hopefully we will manage to answer before we end our session in a while. Okay. Yeah, and thank you so much for everyone who attending our talk show this evenings. We appreciate everyone for attending. And please be informed that this session are conducted on every Thursday from 8 p.m. to 9 p.m. And it will be live, originally live from our Facebook page, which is Excel Academy of Real Estate. So you can tell your friends, your family to like our and follow our Facebook page. So hopefully you can get notified of our talk show every week. Okay, as we will be discussing and sharing a lot of interesting topics every Thursday by our very respected speaker, and one of them is Mr. Patrick. Okay. So, other than that, we also offering a seminar on this coming November and December. It's a 3-hour seminar, CPD seminar. So, if you are interested, you can follow and go visit our website, which is excelacademy.realestate.my. So, you can get to know what is the CPD course that we are offering at Excel Academy. And for your information, our next course, which is on November and December, we are going to talk about another topic on the strata management topics as well. And one of the topics that we are sharing, that we are offering on December is managing strata properties by Mr. Patrick, as he will be talking about the dealing complaints, the meeting as well, and how to tackle the issue and complaints. Okay, so if you are interested, don't forget to visit our website, excelacademy.realestate soon to register because we will be sharing and talking about these interesting topics. Okay. So yeah, we can see there's numbers of questions here. So guys, feel free to write your questions, and hopefully we can manage to answer before our session ends. Okay,
All right.
there you go, Mr.
Okay.
Patrick.
Yep. So you have to come back to the issue of the proprietor. So what I mentioned to you earlier, I just wanted to confirm. If I could be given some time, I'll give you a more detailed answer a little bit later. But this is one of the things that you can call it a kind of a punishment. In the past, those people who do not collect their strata titles, they had all the time in the world to do it. Now they are imposing penalties for delays in you applying for your strata titles, and you may be denied the right to vote as well. But as a general rule, I can say this: for the purpose of attending a meeting, all who are owners are also entitled to attend, even though they may not be registered. The idea of the management corporation, of course, is that once the one-fourth of the share units are issued, then they will start their work straight away from there. So, even though they have not claimed their strata titles, they can still attend the meetings and votes. All right.
Okay, thank you so much. Okay, Mr. Patrick, the next question is coming from our last participant again, which is
Mhm.
from Fazil Mat Isa. And the question is about quorums and votings against. If after many hours of AGM, the quorum left the meeting, in case of special resolution voting, how do we calculate the voting numbers? Shall counting be based on the existing attendance or the originally captured quorum?
Okay. The question of quorum is a question, as I mentioned in the beginning, something that has troubled people for a very, very long time, right? So, whether the quorum must be there throughout the meeting or whether the quorum must be there only at the beginning of the meeting. Now, the general law of meetings is that a quorum should be present only when the meeting proceeds to business. Meaning the quorum should be there at that particular time. Now, what does the special resolution says? Look at the definition given in the Act, the Strata Management Act. It says this: special resolution means a resolution which is passed at a duly convened general meeting, of which at least 21 days' notice specifying the proposed resolution has been given and carried by a majority consisting of not less than three quarters of the valid votes cast at the general meeting by a show of hands, or if a poll is demanded and taken by a majority consisting of not less than three quarters in number of the valid votes cast on such poll. Meaning that this question I saw it last Saturday, meaning you take the figure captured at the beginning of the meeting. What is the quorum? And then you get a three-fourths resolution. This is the way it works. Otherwise, it will be a mockery. If, let us say, 100 people are there at the meeting proceeds, and the chairman begins a long story, once upon a time, and he goes on and they live happily ever after, and he drags and drags, goes on till afternoon, and then you're left with five people, and then out of the five, you get maybe four people voting in favor, and then you call it a special resolution. No, it cannot be valid. It cannot, right?
Okay, great. Okay, since we don't have a lot of more times, maybe we can have one last question, Mr. Patrick. Very short one questions.
Sure, sure.
It's about a meeting again, which is the questions. Mr. Patrick, can the owner attend the JMC meeting as observer?
Yes, he can. Of course, yes, he can. That's a purpose why notice of JMC meetings has to be put up. Anybody can attend. Of course, you have to inform the JMC that you're going to attend the meeting. So that's the purpose. A lot of JMC meetings are held without being informed. But if you study the law correctly, notice of meetings must be put up. JMC, notice of JMC meetings must be put up, and any parcel owner is entitled to attend as observer, right? Please note, if they are not allowed to attend, doesn't mean the meeting is not valid because they cannot vote. They are just there as observer. But you can raise this up and say your rights have been denied. So the answer to the question is yes, you can.
Okay, so the answer is yes. The owner can attend the JMC meetings as a solver. Okay,
Yes.
thank you so much, Mr. Patrick. I think that's all the question we have today. Actually, there is a lot of question coming, but so I'm so sorry, guys. We don't have not a lot of more time now. So thank you so much, Mr. Patrick, for sharing
No,
and for
no
answering
problem.
the questions. Okay, for the question that we didn't manage to answer, do not worry. We can entertain after this, or you can ask again on our next episode of our the Strata Talk Show. And I think that's all for today. Thank you so much again, Mr. Patrick, and thank you everyone for attending our episode 3 of the Strata Talk Show. Okay, and don't forget to follow our next episode, episode number 4, which is next week's, and we will post the title hopefully by next week as well. So I think that's all for us tonight. Thank you so much, everyone. Take care and very good night.
Thank you all for participating. Maybe some of you I've not been able to give a very thorough answer to some of your questions. I will definitely look into the questions and I'll try to give a more detailed answer at our next session. Right? Okay.
Okay, great. Thank you so much, Mr. Becky. Thank you so much, everyone. Have a good night.
All right. Good night. Good night. Thank you, Jamil.